Straight ahead on Law and Crime Daily.
Linking the two of these folks together is still going to provide a modicum of prejudice.
A major decision in the cases against Chad Daybell and Lori Vallow in the deaths of her children.
Breonna Taylor's mother calls Kentucky's Attorney General a liar after he failed to indict most of the officers who pulled the trigger and killed her daughter. Plus, a convicted Chicago cop killer learns his fate.
And a former professional baseball player on trial for triple murder. Police say he fled the crime scene and then attacked a canine.
It's almost like an old wrestling move where the dog kind of was picked up and then dropped on top of his head.
Law and Crime Daily covers court cases from coast to coast.
And welcome everybody to Law and Crime Daily. I'm Aaron Keller along with Brian Buckmire and Terri Austin. We begin in Idaho where a so-called doomsday cult couple is accused in the deaths of two children. Prosecutors want Chad Daybell and his wife, Lori Vallow, tried together. The pair is charged with conspiring to alter, conceal, or destroy evidence after the bodies of Vallow's two children were discovered buried in Daybell's yard. They're not charged with murder. Lori Vallow's attorney is not objecting to having the trials at the same time, but Chad Daybell's attorney is. The state says the evidence and the witnesses against the couple are the same.
Both of the deceased children were found on Chad Daybell's property in Fremont County, Idaho. They were found after law enforcement discovered a text from Chad Daybell to his now deceased wife, Tammy, matching that text with geolocation data from the phone of Lori Daybell's now deceased brother, Alex Cox, gave law enforcement the location of the children's bodies. The Daybells are charged with conspiracy because the evidence which the state will present shows that there was a plan between the defendants in regards to the fate of Lori Daybell's children. The evidence in this case, the state believes, will demonstrate that the concealment of Tylee and JJ's bodies are the result of the same plan and the same series of acts or transactions which constitute the offense for which both defendants are charged. And that is the standard set forth in Rule 8B.
Chad Daybell's defense argues that while the allegations against both defendants are similar, having their trials at the same time would cause prejudice.
But Mr. Wood's argument, Judge, to suggest convenience to the court and expense to the county and the difficulty of witnesses is secondary. And primarily, Judge, the importance is Mr. Daybell going to get a fair opportunity to present his side of the story? And is it going to be able to be presented without any kind of prejudice or bias? Or are they going to infer anything from any other witness or any other defendant or anybody else that does not afford him an opportunity to fairly present his case? The fact remains is what I would ask the court to do is reserve a ruling on joinder, allow the argument to be made in terms of severance once Mr. Wood and I have resolved our discovery issues, and decide at that point whether or not we're going to proceed in a common trial.
The judge said he did agree with the prosecutor's arguments and issued his ruling right on the spot.
I think quite concerning given our circumstances right now under our COVID restrictions and the difficulties we have even getting a jury trial at this point. The prospect of having two separate trials where two separate juries would have to be impaneled to try each case is concerning as well. And so upon consideration of all that, counsel, I am going to grant the motion to join at this time. As the parties indicated, that doesn't forego the possibility of a future motion for severance if prejudice is demonstrated by the defense in support of that motion.
And remember, Lori Vallow Daybell did not object to the state's motion to have the cases tried together, but she did file several of her own arguments nonetheless. Law and Crime's Terri Austin is here to explain what Lori Vallow wants from the judge. Terri?
Aaron, Lori Vallow Daybell was not present at this hearing, but she has filed court papers demanding authorities release more information in the case against her. Defense attorney Mark Means is requesting recordings, emails, text messages, social media posts, and reports regarding Chad Daybell and other possible witnesses. Those include Vallow's former friends and even her own children. Prosecutors say they've given the defense some of the items, but not all of the material is available yet.
So, Terri, among Vallow's defense requests are autopsy and toxicology reports for the kids and now other deceased people as well. Social media posts, recordings. Is this a fishing expedition or is this a legitimate request?
You know what, Aaron? I don't think it's a fishing expedition. I think it's a legitimate request. And I think that these requests indicate that Lori's attorneys, maybe not Lori, but the attorneys are gearing up to point the finger either at Chad Daybell or even Lori's deceased brother, Alex, because I think they are trying to find information that will take the charges away from her and towards anybody else.
Interesting tactic, interesting theory there, Terry. But remember, she's the mother. Brian, let's look at the law here. Every state seems to play the discovery game a little bit differently. Idaho Criminal Rule 16 says the prosecutors has to turn over automatically everything which makes the defendant appear not guilty. That's pretty standard. Or which would reduce the punishment. That's also pretty standard. But then they've also got a laundry list of other rules, require the prosecutor to hand over other things if the defense requests it in writing. So it seems like here the defense is just exercising its ability to ask and receive.
Absolutely. That's the defense attorney's job, to get all the information possible and to try to show that their client, or at least defend their client in the best as possible. Because you got to remember, the defense attorney does not have the resources that the government has to investigate, the arm of the law, prosecutors, officers, and other things at their disposal. But we're trying to seek justice here, not punishment, and that involves getting all the information.
And real quick, I think we called it here. I think we all said that these cases would probably be joined together. And Terry, that's exactly what the judge did.
Yes, and I think it makes sense. It saves time, it saves resources, and frankly, they're going to probably point the finger at each other at the end of the day.
Exactly. That's a common tactic. We'll have to watch the trial as it unfolds. They're moving very quickly in that direction. Jury selection is beginning in the trial of a Colorado man accused of murdering his son. 59-year-old Mark Redwine is accused of killing 13-year-old Dylan in 2012. The father wasn't indicted until 5 years later when new people started looking into the case. The father faces second-degree murder and child abuse charges. Prosecutors think the victim found so-called compromising photos of his father, which may have resulted in his death. Let's check in now with Chief Investigative Correspondent Brian Ross and what he's working on this week.
Thanks, Aaron. Coming up this week on Brian Ross Investigates, does the punishment fit the crime? The Department of Justice announces a settlement with the makers of OxyContin, the Purdue Pharma Company. They agree to pay $8.3 billion, and the company will plead guilty to 3 felony counts, but no criminal charges against any executives of the company or the owners of the company, the Sackler family. Does the punishment fit the crime? We'll talk with Nan Golden, the artist who led protests against Purdue Pharma.
People wrote to congratulate me, but this isn't a win, it's a spin. There's no justice in this case.
That's this week on Brian Ross Investigates, Aaron, on the Law&Crime Trial Network.
We'll see you there, Brian. And still ahead here on Law&Crime Daily, we'll discuss a request by the mother of police shooting victim Breonna Taylor to have a new prosecutor look at her case. Plus, sentencing for a convicted Chicago cop killer. We'll break down the charges and the sentence when Law&Crime Daily returns in just a moment. Philadelphia is experiencing several nights of civil unrest following the police shooting of a black man armed with a knife. A witness recorded this video and posted it on Instagram. It shows officers following Walter Wallace Jr., who was carrying the knife. The video has been viewed close to 2 million times. Wallace's family told a Philadelphia TV station that they called for an ambulance to help him with a mental health problem. They say they did not request the police. The city has asked residents in parts of the city to stay inside during the unrest. The National Guard is being mobilized to bring the protests under control. To Kentucky now, where the mother of police shooting victim Breonna Taylor is demanding a new prosecutor look into the death of her daughter.
Tamika Palmer says in a 109-page request that a competent and capable prosecutor willing to handle the case involving the officers who shot and killed her daughter should be appointed by a Kentucky office known as the Prosecutor's Advisory Council. Palmer calls her request nerve-wracking, but says someone other than State Attorney General Daniel Cameron must review the case. Here's how she described her own interactions with the AG. Following the proceedings, Attorney General Daniel Cameron had me drive nearly an hour to his office in Frankfort, where he proceeded to tell me that his prosecution team was only able to obtain an indictment against LMPD officer Brett Hankinson. The Attorney General advised me that the grand jury declined to indict other officers and that his team had done the best they could. A.G. Cameron and one of his prosecutors then advised me that I should consider finding peace through the Lord, and watched as I sobbed uncontrollably. Palmer described having to pull off the highway on her way home because she was sick over what was said. Meanwhile, Cameron was telling the press that the grand jury determined the shooting was justified. He announced to a worldwide audience that his prosecutors walked the grand jury through every homicide offense, that the grand jury applied the facts to the law, and that the grand jury, upon reviewing the evidence, determined that the officers were justified in killing Breonna. These statements were flat-out lies, Palmer's document says.
So, Brian, the anguish that mother felt is something that I felt reading the documents, but you've looked into the law underlying this, and we were talking earlier, you aren't sure she has a strong argument legally speaking.
Yeah, so the law that she's citing to, unfortunately, and I think it goes throughout the entirety of this case, that it doesn't seem like the law has the equipment to properly give justice to Breonna Taylor. The law that she's citing to would typically be used to take a case out of a county district attorney's hand and give it to that of the attorney general. But it doesn't really give guidance as to what happens when the attorney general messes up in such a way and to give it to someone else. And so it's almost like the law has been failing Breonna Taylor over and over and over again.
And this is where reform movements come from. Terry, let's talk about the Attorney General's statements, because the mother is really throwing the book back at the Attorney General. Do you think he thought that this uproar would swell up with grand jurors speaking publicly, speaking on television, filing lawsuits to be able to speak? And now we have an entirely different narrative of what went on in that secret proceeding.
Well, that's exactly right. And listen, this is why I agree with Brian, actually. I think it's going to be hard to get another attorney general or prosecutor to handle this case. But I think Cameron should recuse himself, and he should recuse himself because on the one hand, he told the grand jury that this is all there is. He didn't present all of the homicide offenses. And on the other hand, he's announcing in public that he did just that. So he lied. And I think it's a conflict, and I think he should save all of us and step down.
Harsh opinions from Terry and great legal insight from both of you, Terry and Brian. And still to come here on Law and Crime Daily, we'll take you back to the trial of a pro baseball player accused of using a bat as a murder weapon. But first, a convicted cop killer faces his victim's family and learns his fate in a Chicago sentencing hearing. We're back with that in just a moment. A sentencing hearing for a man convicted of killing a Chicago police commander. Law and Crime's Brian Buckmire has that report. Brian?
More than 2 years after Commander Paul Bauer was shot to death, his family now says they're relieved, but that justice will never be served so long as the defendant is still alive. Shamari Leggetti entered court for a final time as a judge prepared to hand down his sentence. Investigators say Leggetti was dressed in body armor and was holding a gun with an extended magazine as he gunned down Commander Bauer in a stairwell in February of 2018. Police officers worked to capture a suspect for killing one of their own.
A man who viciously murdered a Chicago police officer was convicted on all accounts. Here was a man who had devoted his entire life to his family and the city of Chicago, and he was taken from us far too soon.
The late commander's widow and daughter spoke about Bauer's life, how he loved to read and cared deeply for his family.
We'll never stop mourning the loss, but we're delighted that there was justice today.
A jury convicted Leggetti of 6 charges, including first-degree murder of a law enforcement officer. A defense motion for a new trial was denied.
It is the sentence of this court that the defendant, Shamari Leggetti, shall serve life in prison without the possibility of parole.
It's a tough sentence. Brian, what's the status of the death penalty in Illinois? We heard that the family said that they wouldn't feel that they were truly receiving justice while the defendant was still alive.
So if you went back before 2011, 2010, if you had murdered someone in the first degree, that's a life sentence. But if you had done it to a peace officer or to another governmental official, then the death penalty was on the table. However, even back in 2002, the former governor back then was commuting sentences for the death penalty. But as of 2011, that was disbanded. So even if it's on the books, technically, there's no death penalty in Illinois.
Yeah, Terry, most states do increase penalties for the killings of police officers, firefighters, and other government services. And there is still an inkling of that in Illinois law.
That's right. And most states do it, and there's a reason for that, including here in New York State. The rationale is that when you kill a police officer or another government official who's there to serve you, to protect you, you should have a higher sentence. You should have the maximum sentence that you can possibly get because they're there to protect you. And it's particularly heinous when those individuals are killed in the course of their duty to protect you.
Such a sad case all the way around, Brian. I know that you looked into this a lot earlier. Was the punishment the proper one here? No chance at parole?
I think it is. I'm always a defense attorney. I want people to have the ability to redeem themselves. But when I look at the facts, when I look at the 2-page letter that he sent to the family, his lack of remorse, I think he has the constitutional right to be defended, and I would do that. But as a human being, I think this is the right punishment, and I think the court found the right decision.
I think we find the right decisions when we have due process, and good defense work results in due process. When we have due process, we can feel comfortable with the outcomes of cases. It sounds like here we three agree that, in our opinions, is what happened. When we come back, is it a crime punishable by death or a mental health disorder which led to a tragedy? That's the choice a California jury must make in the trial of a baseball player accused of triple murder. That case is coming up next. A former professional baseball player is on trial after authorities say he used a baseball bat to beat 3 people to death. Brandon Willie Martin faces 3 counts of first-degree murder for the deaths of his father, his uncle, and a security system installer who just happened to be there. Prosecutors accuse Martin of committing the murders out of anger after losing his baseball contract. The defense says Martin suffers from mental illness. Police say Martin fled the murders after committing the crimes, leading them on a high-speed chase through residential neighborhoods.
I yelled at him to put his hands outside the window, and in case he couldn't hear me, I also used my PA system that's inside our vehicle to put his hands out the window. We're not going to walk up to a vehicle on a high-risk stop. That's not how we're trained. The way we're trained is we're going to call the person back to us.
Okay, and did you do that?
No.
Why is that?
We didn't have the opportunity to.
And why is that?
As we were still set up, I saw the driver's hands tuck back into the truck, and the truck then sped off. I remember it leaving at a high rate of speed. That was concerning for me, given we're in a residential community.
From there, Martin fled again. The officer's backup unit was able to follow him through the neighborhood until he eventually collided with a police cruiser.
At the termination of that pursuit, or where it ended, I saw the subject get out of the vehicle and start running northbound on one of those.
And you're familiar with that area?
I am.
Okay. When you saw the suspect leave and start going on towards Buena Vista, what did you do?
I immediately went around, because there was a collision between a unit and the Raptor. I went around both units and the Raptor and followed the subject. While he was running, I was on my unit, or my car.
Okay. And were you able to stop him?
No.
Where did the subject go?
He went over it was like an old wooden brown fence behind a residence in Buena Vista.
More units arrived to surround the house. A police helicopter provided air support, and canine units joined on the ground.
He was on the ground, laying down with his back towards us, motionless.
Okay. And did you call out to the suspect?
At that point, our canine officer did. Immediately, the dog will kind of poke the person around a little bit first, and then it actually latched onto him, and I can't remember where. The dog's biting, and the handler's still giving him orders to comply. So he was punching the dog. If the dog's biting me here, and he was kind of just hitting the dog on the top of the head. I saw when it's almost like an old wrestling move where the dog kind of was picked up and then dropped on his top of his head. Like he picked him up and then dropped him on his, that's when we all jumped in. Like towards the top of his head. So like where he was being latched, where the dog was latched at in between the lower region, he was just kind of slammed down. Corporal Bennett removed the dog from the bite. We took the subject to the ground, at which point he landed on his stomach.
This is vicious. Okay, so Terry, it seems to me legally that the defendant's flight might get in the way of his insanity defense. Under California law, an insanity defense asks these questions. 1, did he understand that he was doing something that was criminal? Or 2, did he understand it was morally wrong? So if he fled, arguably he knew it was wrong or that it was criminal, right?
Aaron, I agree 100%. And, you know, here's the point. Generally, when a defendant attempts to flee the scene, it means that there is some consciousness of guilt. But I'm sure, and I think Brian is going to agree here, it could also indicate that the defendant had some other explanation for why he fled. I mean, perhaps he was delusional. He thought everyone was trying to get him. The police were, you know, in some sort of conspiracy to hurt him, and that's why he fled. But I agree with you. It does seem to me that he knew he was wrong.
Okay, Brian, take it away here. If you want to disagree with us both, go for it right now.
So I disagree with you both.
Okay.
First and foremost, when the insanity defense is applied, it's applied to the time in which the incident occurred, not the flight thereafter. Second of all, when we're talking about the insanity defense, it's whether or not they understand that it's criminal or moral. Fight or flight is instinctual. There is an actual part of the brain that is triggered when an individual is fleeing from something. I've got a 70-pound Doberman that is trained in a similar way to those officers are trained, and I'm talking about the canine unit. If you want to try being chased by my dog, Aaron, trust me, it's fight or flight, and that's not something that you're actually consciously deciding. It's something your body is reacting to.
Look, I've seen pictures of your dog. If your dog comes after me, I'm running. I'm not fighting back. That's just not going to happen. Well, look, a couple of different views on this. The jury's going to have to decide. Brian and Terry, great discussions here as always. Thank you for watching here on Law & Crime Daily. We'll see you next time as we discuss justice in America, and there's a lot to talk about.
Hi, I'm Dan Abrams. In the exploding legal and true crime genre, Law & Crime is the only network that has it all.
Good evening and welcome.
This is a complicated case.
Don't really jump to conclusions.
We break down the case of a serial killer.
Another day of drama between both sides.
From multiple live trials daily to original and compelling programming, the Law & Crime Network is everywhere, and we invite you inside the jury box. This is Law & Crime.